Today I'd like to talk about another question concerning intellectual property ownership. And that question is, if you've got a couple of people who own a limited liability company, who owns the intellectual property to the stuff that they create after they've formed the limited liability company? In another video, I explained that the default rule generally is that the person who creates the intellectual property will own the rights to it. There are some exceptions to that rule. For example, if you're an employee and you create the intellectual property within the scope of your employment, in other words, that's what you were hired to do, was to create that stuff, to code that software or to create that graphic design work or something like that, then the exception is that the employer will own the copyright to that intellectual property, to that work. If you're a member of a limited liability company and you create something that's protected by intellectual property rights, who's going to own that? Well, in a limited liability company, a member is not technically an employee, even though the member may be providing the same type of services for the LLC that an employee would provide for an employer. And when I say member, I mean owner. So a person who is an equity owner who owns equity in a limited liability company is referred to as a member. So we're back to the default rule. The default rule is that the person who created it is going to own the intellectual property rights. And in a limited liability company, we'll never get to the exception to the rule, the exception that the employer will own the copyright to stuff that's created by an employee within the scope of their employment. We'll never get to that point because a member is technically not an employee of the limited liability company. So what do? How do we resolve that? Well, we need a written legal document. And I've seen this done a couple of different ways. One is that I've seen the operating agreement, that's the contract between the owners of a limited liability company, that the operating agreement will have provisions in it that indicate that everybody who's a member of the company agrees that if they create something for the company or on behalf of the company, that they're already assigning or transferring their rights to that future work into the limited liability company. So that's one way I've seen it done. Another way I've seen it done is for all of the owners, all the members, to sign a separate written agreement. A lot of times it's called an intellectual property ownership agreement, but it's basically a separate standalone contract where the members of the LLC, the owners of the LLC, agree that as they create stuff in the future for the LLC or on behalf of the LLC, that those rights will be transferred into the LLC. That way, we're assured that the limited liability company ends up with all of the intellectual property rights to the stuff that's created by the owners or the members of the LLC. I'm Joel Ankeny. I'm a lawyer who helps people start, run, buy, and sell small businesses. And many times those transactions have intellectual property ownership issues involved in them. If you have questions about intellectual property rights, intellectual property ownership, starting or running, buying or selling a small business, you can contact me by following the link below to my website, or you can just leave me a comment below with your question and I'll get back to you. Thanks. Stay tuned for more videos from me to answer questions that people frequently ask me about starting, running, buying, and selling a small business, or buying, selling, or leasing commercial real estate.